Hello everyone, welcome to this EUPOP guest lecture in this final year of the EUPOP project, which is actually completing in August 2022. We are very happy on behalf of the School of Law of Euclid Cyprus and the EUPOP team to have you with us. It's a real pleasure to welcome our guest speaker and all of you to this guest lecture on a very important combination of topics, which is the impact of right-wing populism on the family rights of sexual minorities in Europe, which I think we would all agree is a very valuable but perhaps under-researched topic. So we are very proud to host Professor Tryfonidou and listen to what she has to say from such an expert. So thank you, Alina, for joining us, for your willingness to and enthusiasm to speak about this topic, and also for enhancing our EU project by actually providing us with a working paper, which we will review with great interest, Andreas and I. So thank you very much for this too. Also, thank you to all the participants who are here today with us. As you can see, we are recording, so you'll be able to go back to this guest lecture. And thank you to all the colleagues who have worked on today's event, the usual suspects, Nicolas, Andreas, and Kostas, and the others who have tried to help us. And thank you so much. So it's very nice to see a mixture of professionals, academics, and students, and wider, people from the wider public for a topic which is societal. So before I continue, I will just remind everyone what we're doing here. We are doing the guest lecture. We are recording it for educational purposes because we would like to broaden up access to this resource as an educational resource. So please keep your cameras and microphones off and use the chat function in the MS Teams classroom to ask questions or make comments. If you do not wish to appear on the chat room, just don't use it and you won't appear anywhere. So I'd like to remind everybody that each of the speakers, in this instance, Alina particularly or primarily, but also other participants will take part to this guest lecture for educational purposes. And this is an educational setting. That means that each participant will, whatever each participant will provide verbally, electronically, or otherwise, must not be accepted or interpreted as either legal advice or any form of advice. You may view materials at your disposal in the MS Teams classroom, which you are free to take away from this webinar, but use with the necessary acknowledgements. In this case, Professor Tryfonidou, if you're using, if you are going to download the slides, please make sure that you are using the right acknowledgements. So what remains for me to do with great pleasure is to introduce the topic and to introduce our speaker. The topic, I think, is extremely ambitious. So I thank Alina for actually, coming up to the challenge, because I do think that, the combination of the consideration of the phenomenon of right-wing populism in Europe, coupled with the perceptions, their perceptions of authority, family structures that are perhaps conservative, and attitudes towards sexual relations, make it a complex but very important societal topic. So Professor Tryfonidou examines the perceived opposition between the extension of basic family rights to sexual minorities, such as the right to marry or the right to become a parent, to ideologies and preconceptions that these are still, in many European countries, the prerogative of persons who do not belong to a sexual minority. In the EU, fortunately or unfortunately, one cannot tell at this point, but for us from an EU perspective, probably it's unfortunately, family law remains an area of exclusive state power or exclusive state competence, which of course creates two sides of the same coin. So on the one hand, rights are created, but on the other, the enforcement of those rights is largely taking place at the national level, which means that we have discrepancies between the level of protection of minorities across member states, and that we have different national policies on the same issues. And such national policies can be influenced by perceptions, negative perceptions on the rights of the family rights of sexual minorities. So this is what Professor Tryfonidou is going to try to explain to us and demonstrate. She goes even further by saying something which is even more interesting from an EU perspective. She goes to the supranational level and argues that, you know, this phenomenon is also present at the European courts level, whether it is the Court of Justice of the European Union or the ECHR, the Strasbourg Court. And she argues that these courts are sometimes reluctant to deliver rulings regarding the family rights of sexual minorities because issues of enforcement of those judgments will resurface at the national level, because such rulings are probably met with some oppositions or opposition in some member states of the European Union or in some European states. So this is a very interesting argumentation, and this is an argumentation that deserves to be heard and to be reflected upon. Now, I'm very privileged to introduce Professor Alina Tryfonidou. We have been very good friends for a number of years. Actually, we met many years ago at the University of Leicester. Don't count, Alina. But for the moment, currently, Alina is a professor of European law at Minneapolis University in Paphos. So Alina is back in Cyprus after many, many years in the UK. She's also visiting professor of law of the University of Reading in the UK, where she actually was holding a position before she returned to Cyprus. She began her academic career in 2007 as a lecturer in law at the University of Leicester in the UK, and this is where we met. She subsequently joined the University of Reading as a lecturer in 2011, and was promoted to associate professor in EU law in 2013, and then professor in law in 2018. She joined Minneapolis University Paphos in April 2021, so a year ago. Alina, happy birthday for the first year. And Alina was also, well, Alina obtained her LLB in 2001, her LLM in 2002, her PhD from King's College London in 2008. And she also taught European law as a visiting tutor and as a visiting lecturer in different places in between 2005 and 2011. She's an associate of King's College since 2008, a non-practicing member of the Cyprus Bar since 2003, a fellow of the Centre of European Law at King's College London since 2007, and a fellow of the UK Higher Education Academy, or now known as Advanced Higher Education, since 2016. This is something that also most of us here at UCLan Cyprus are members of, because it's very important in UK education institutions. In 2004, Professor Tryfonidou completed a Blue Book traineeship at the European Commission at the DG Market, now DG Grow. And in 2010 and 2011, she was an IELTS visiting fellow in London, standing for the Institute of Advanced Legal Studies. Professor Tryfonidou is a member of the European Commission expert group on the recognition of parenthood between member states, which aims to assist the European Commission in the preparation of a legislative proposal for regulation which will require the cross-border recognition of parenthood in the EU, a very, very important issue. And many congratulations to Alina for making it to that expert group. Personally, I know how difficult it is to be selected for those any of the expert groups of the European Commission. So very well done. You make us proud. And she also sits on the editorial board of the Cyprus Review. Alina's main research interests lie in European law, focusing on EU freedom, free movement law, family law, and the rights of sexual minorities. Having said all this, thank you very much, Alina, once more. I am going to give the floor to my colleague Andreas, Dr. Andreas Marcou, who will, as I said, introduce what else we have in the pipeline that is relevant to today's guest lecture, and also introduce some of the concepts for today. Thank you very much.
Thank you very much, Stephanie. And first of all, thanks to Professor Tryfonidou for accepting our invitation and for delivering this lecture today on a topic that is extremely interesting and quite timely. I won't talk for long, so I don't want to bore you. I'm just going to say a few things about the EUPOP project that we have run at UCLan Cyprus for the past 3 years. I'm going to say something about the new project that has actually just begun. And then I'm just going to say a couple of things about some of the main issues related to populism on which I conduct my research. So to start, EUPOP is a project that has been running for 3 years, as Stephanie mentions. It is going to terminate in August. Within the framework of EUPOP, we have delivered multiple lectures and educational programs, and we've also published a journal in addition to a working paper series. For all of this, you are free to visit our website, which I'm later going to provide in the chat, and you can subscribe to our mailing list. Within the framework of the program, in addition to today's lecture, we also have a couple of events coming up. The first one is the final conference for the EUPOP project. This is going to take place on the 12th and 13th of May. And the next event is the summer school, that our annual summer school. This is the third summer school that we'll hold within the framework of EUPOP. This is going to take place in June. For all of this, you can find more information in our website. Now, in addition to EUPOP, we've recently secured EU funding to start and run a center at the School of Law of UCLan Cyprus. This is the Center for the Rule of Law and European Values. This is going to run for the next 3 years. This is a big project that intends to study the state of the rule of law, both from an empirical perspective, so how we actually understand the rule of law, how the rule of law is treated in Cyprus, but also from a normative perspective, dealing with questions such as what is the state of the rule of law within the European Union, what are the differences in the treatment of the rule of law in different European countries, why those differences, can we actually conceptualize the rule of law and other European values in a way that can help the European Union better protect those core values as enshrined in Article 2 of the Treaty of the European Union. Now, that's enough for our 2 projects. I'll also add in the description a couple of links for the social media websites for Krolev, the center that we run at the university. And you can also subscribe to the mailing list for that and keep updated for all the future events that we're going to hold. Now, what I want to do now is say just a few things quite briefly about populism and the way populism affects the rule of law and democracy, primarily with just a mention for human rights, as I wouldn't want to step on Professor Tryfonidou's toes here. I'm sure that she'll have much to say about that and the rights of particular minorities in light of this climate of populism in Europe. There's a lot of debate about the most accurate way to define populism, but what I want to do now is just provide a rather uncontroversial account, quite broad and easy for everyone to understand. On this account, populism is a discourse, a political discourse. It's essentially a way to talk about politics. And the way that defines populist narratives is the depiction of a society divided into two competing classes. On one hand, you have the ordinary people, and on the other hand, the elite. And the crucial point here is that this distinction is moralized. So within this distinction, the ordinary people are always noble and true and good and uncorrupted, whereas on the other hand, the political elite are always and constantly corrupt, evil, exploiting the ordinary people, and so forth. So populism inspires and feeds on the anger on the part of the ordinary people who are exploited by a sort of political elite. Even though there might be different kinds of populism, both left-wing populism or right-wing populism, for today, I am going to focus on right-wing populism the same way that Professor Tryfonidou is going to focus on right-wing populism in her lecture. The most commonly discussed cases of right-wing populism, or perhaps first let me say a couple of things about right-wing populism, because as I mentioned earlier, populism is a type of discourse, a type of way to talk about politics, and it tends to connect with different ideologies. When it comes to right-wing populism in Europe, it tends to combine with nativist, ethno-nationalist ideologies. And a core belief of these ideologies is that national identity is under threat from others. Those others are typically portrayed as the elite and must be protected. So this right-wing nativist populism is typically associated with racism or xenophobia, and it's exclusive in nature. I'm going to focus on right-wing populism in a couple of European countries, Hungary and Poland. Those are the most common culprits when it comes to right-wing populism, but they're by no means not the sole culprits, right? So other countries in Europe, they have right-wing populist parties. So in Italy, we have Lega Nord. In Germany, we have Alternative for Germany. In France, we have the Front National. But Hungary and Poland tend to be the two countries with which most people within the European Union are preoccupied, primarily because the populist parties in those two countries form the government. So they have considerable power, much more than other minor parties in other European countries, and they are able to enact political change in order to reflect their agenda. So what I'm going to do now is I'm going to mention a few ways in which those parties have acted in ways that undermine the rule of law and democracy primarily. In general, populist rhetoric has an uncertain relationship with the rule of law, because a common feature of populist narratives is that we have a charismatic leader who embodies the will of the ordinary people, and that leader is going to protect the interest of the ordinary people against the evil elite, right? So in a way of taking on the elite and delivering the will of the people. But this often clashes with principles of the rule of law. A basic function of the rule of law is that it limits political power, even if that political power is supposed to be representing some democratic majority. So we typically associate the rule of law with principles of equality before the law, constitutionalism, or judicial independence, because those are ways in which we tend to limit potential abuses by democratic majorities. And so when a populist leader tries to enact the will of the people, sort of say, then the rule of law is meant to be there to contain the things that the leader of the populist party can actually achieve. And so it's not a surprise when it comes to the Law and Justice Party in Poland and Fidesz in Hungary that they have taken action to undermine judicial independence and weaken the rule of law in an effort to achieve and maintain greater political power. So one thing that the Polish Law and Justice Party did was to lower the retirement age of judges from 70 to 65. Now that decision forced many judges out of the bench, and it gave the opportunity to the ruling party to essentially pack the court with judges who are sympathetic to the agenda of the government. That way, that agenda would not be limited or otherwise impacted by decisions of the judiciary. Other related steps include attempts to target the judiciary and their ability to decide cases freely. In particular, the Law and Justice Party has adopted measures to discipline judges who, quote, behave unethically, right? And that law was used to target judges who maintained a critical stance against the regime. Recently, a mechanism designed by the European Union to protect the rule of law is the conditionality mechanism, a mechanism that intends to, or is designed to withhold funds from countries that do not adhere to rule of law conditions. This mechanism was recently approved by the Court of Justice, so it remains to be seen how or if the European Commission uses that mechanism. Next, I'll say a few things about Hungary and its relation to democracy. Viktor Orban is the leader of Fidesz, the populist party in Hungary, and since 2010 that he has been in charge, he's talked about instituting an illiberal democracy in Europe. So the idea behind this is that Orban talks about Hungary becoming a sort of democracy where the will of the people is realized beyond any liberal constraints, and in particular rule of law constraints. I'm just going to give one simple example about the ways in which Hungary has, or Fidesz has acted in ways that undermine democracy and democratic norms, and that has to do with attacks on free press and on academic freedom, measures that target free news media were quite prominent even before COVID-19, and after the pandemic, those essentially proliferated with rules limiting the things that news media and anyone can say regarding the treatment of, government measures to limit the spread of COVID-19. In addition to that, attacks on academic freedom essentially resulted in the expulsion of the Central University, European University from Budapest. It has now moved, or most of its departments have now moved to Vienna. So this goes to show you how limiting access to information and free speech is a fundamental way in which democracy is undermined. And with that, I'm going to conclude my comments. I'm going to cede the floor to Professor Tryfonidou, who is going to talk about another very important way in which those populist parties have acted in the past and continue to act in ways that violate individual rights of minorities. So thanks very much for your attention, and I look forward to Professor Tryfonidou's lecture.
Thank you very much, first of all, for the invitation. It's always a pleasure and an honor to present at UCLan Cyprus, the law school. Actually, it's the second time that I'm speaking at UCLan, the first time though online. The previous time was for a very different topic. It was for golden passports, Stéphanie, you may remember. Okay, so I just want to check, can you see my screen? Is it shared? Yeah, okay.
Yes.
Okay, let's just make sure. Right, so what I'm going to speak about today, as has already been said, is about the impact of right-wing populism on the family rights of sexual minorities in Europe. Before I actually start with the lecture, I would like to explain that, well, first of all, before I explain anything, I want to say that, as Stéphanie rightly said, this is a very ambitious topic, over which actually I have lost a few nights' sleep until I figured out how I was going to approach it. I have done quite a lot of research on the rights of sexual minorities in Europe, and I will explain by what I mean in Europe. But it's the first time I'm actually touching the issue of populism, although it's a very topical one. I have never done any research previously on it. So it was quite interesting to try to connect. They are clearly closely connected, these two issues, populism on the one hand and the rights of sexual minorities on the other. But at the same time, this, again, as noted by Stéphanie previously, this is a topic which is massively under-researched, and definitely it's under-researched by legal scholars. So most of the literature that I have found, which speaks about sexual minority rights and populism, has been literature which has been produced by non-legal scholars, so sociologists, political scientists, etc., etc. Now, what I'm going to speak about, as we've said, is about the family rights of sexual minorities, and as I say, in Europe. Here, I would like to explain that I'm going to approach this topic from a supranational perspective, meaning I'm going to examine how right-wing populism has affected the family rights of sexual minorities at the supranational level, meaning when judgments have been delivered by the European supranational courts, namely by the ECJ of the EU and by the European Court of Human Rights of the Council of Europe. And also, to a certain extent, I'm also going to briefly refer to the actions of some EU institutions. Obviously, there are quite a lot of things to say about the rights of sexual minorities in Europe under European law. So it's impossible to cover everything either in the lecture or even in the working paper. So my treatment of this question of the rights of the family rights of sexual minorities under European law is quite selective, simply, and is done in a way which simply shows how right-wing populism may have had an impact at the supranational level. Okay, now, what do we mean by sexual minorities? Sexual minorities consists of persons who have either minority sexual orientation or a minority gender identity. For the purposes of today's lecture, however, I'm using a more limited definition for sexual minorities. And whenever I speak about sexual minorities, I will be referring simply to persons who have a minority sexual orientation, meaning LGBT persons, lesbian, gay, bisexual persons. And I'm going to speak in particular about the claims that such sexual minorities have made to the European institutions for family rights, for equal family rights with everyone else in the society. And I'm going to say in a few minutes what will be my actual research question. So the first point I would like to make is that, as we all know, especially in the last decade, Europe is increasingly marked by the growth of right-wing populism. In Central and Eastern European countries, right-wing populists tend to favor traditional forms of authority and patriarchal family structures. Andreas already has spoken, has explained very well what we mean by right-wing populists and how they view sexual minorities. They do indeed have very conservative attitudes towards sexual minorities, in particular in the specific geographical context of Central and Eastern European countries. Right-wing populists tend to consider homosexuality as an unnatural, corrupting force on society and as a threat to the traditional family, which is considered to be a very fundamental institution for the society of their countries. So right-wing populists in Central and Eastern European countries oppose the extension of basic family rights to sexual minorities. Now, the next point I want to make is that, as has already been previously explained by Stéphanie, if I remember well, family law is an area of exclusive state power, meaning that it is still European states and not the EU, for instance, that decide how to regulate family law, meaning who can marry whom, who can become a parent and in what ways, who can adopt a child, what is the procedure and all this. And obviously, it is up to individual states to decide whether they will allow two persons of the same sex to marry, whether they will allow same-sex relationships to be legally recognized, and if yes, in what ways, and as well whether they will allow same-sex couples to be the joint parents of a child. Family law is an area that cannot really be regulated at a supranational level. It's left to the states. So in European states where there is a right-wing populist government, like, as Andreas mentioned before, in Hungary or Poland, or where the government is reliant on the support of right-wing populist groups, right-wing populist ideology heavily influences national family policies and laws. So what this means is simply that in such countries, sexual minorities enjoy very little, if any, family rights. So, for example, if someone checks what is the situation with regard to sexual minorities in Poland, you will see that they cannot, two persons of the same sex cannot marry, they cannot actually have their relationship legally recognized in any way, and also, obviously, they cannot be recognized as the joint parents of a child. In Hungary, there is some provision for some kind of recognition of same-sex relationships, but same-sex marriage is out of the question, and same-sex parenting, again, is not even considered to be introduced in any way, to be recognized. Okay, so my research question is, what is the role that the rise of right-wing populism in certain European countries, namely Central and Eastern European countries, may have played in limiting the family rights of sexual minorities in Europe at the supranational level? So having introduced these points previously, meaning that right-wing populism is becoming increasingly prominent in some European countries, and having seen how right-wing populism in that particular geographical context approaches the rights of sexual minorities, in particular the family rights of sexual minorities, I wanted to consider what may have been the role that this has had on the response of the European institutions to claims by sexual minorities for family rights under European law. Okay, well, Andreas has already spoken about populism, but since I have this, I will very, very briefly going to go through this. So populism, it's a term that is impossible to define in a universal normative fashion. But as one of the first scholars that has written about populism has noted, it's exceptionally vague and refers in different contexts to a bewildering variety of phenomena. So actually, we cannot really speak of one type of populism. There are a number of different, let's say, political moves and ideologies can be brought together within the group of ideologies which are considered populism. It is meant to be a form of politics of the people against elites, whether at national or supranational or international level. The essential aim of populism is to appeal to the pure people who feel that their concerns and wants are disregarded by the corrupt elite. So populists claim that they speak in the name of the people, that they are there to fight for the will and the desires of the people whose desires are disregarded by the corrupt elite. Now, again, Andreas has already spoken about this, but I'm going to also speak briefly about it. What do we mean by right-wing populism? Obviously, we have left-wing populism and right-wing populism, and of course, a lot of other ideologies in between. Now, right-wing populism is a political ideology which combines right-wing politics and populist rhetoric. So it employs anti-elitist sentiments, and it claims that it speaks in the name of the people. This is the populist element of it. But unlike left-wing populists who are focusing more on economic issues, right-wing populists are generally concerned with cultural issues and proclaim that their main aim is to protect the national culture and identity from perceived attacks by specific others. So right-wing populists do not just distinguish the pure people from elites. So they don't just say, okay, there is this dichotomy between the pure people and the elites. They actually bring a third party, let's say, in the equation. And this is the specific others. So the right-wing populists distinguish also between the pure people on the one hand from specific others. And these specific others can be defined differently depending, again, on what is important for the specific right-wing populist group that is at issue. So, for example, specific others can be the immigrants, ethnic or racial minorities, criminals, and of course, sexual minorities. Now, right-wing populists often claim that it is the aim of the corrupted elites to promote the interests of those specific others at the expense of the pure people. So how things go when it comes to right-wing populism is that you have, on the one hand, the pure people, then you have opposite them the elites who are ignoring the interests and the wants of the pure people because they are corrupt. And then at the same time, you have the specific others who are, let's say, the enemy of the people as well. And these can be immigrants, sexual minorities, criminals, etc., etc. And right-wing populists often argue that the corrupt elites have as their aim actually to promote the interests also of those specific others at the expense of the pure people. One point I would like to emphasize here is that right-wing populists do not share the same beliefs and attitudes throughout Europe. So I have actually recently read quite a few articles where the author was at pains to explain that, no, yes, traditionally it was thought that right-wing parties, right-wing populists were against sexual minorities, but actually in Western European countries where the rights of sexual minorities tend to fare better, let's say, than in Central and Eastern European countries, and where same-sex relationships, for example, are considered more accepted within society, their right-wing populists do not treat sexual minorities as the specific others, but actually consider them part of the pure people, and actually within their arguments, they actually say that specific others are those who are from a different ethnic or racial background, and which actually exclude members of the sexual minority, of sexual minorities. So for this reason, my paper, and actually this lecture, is going to focus on right-wing populism in the center, in the Central and Eastern European context, where exactly sexual minorities are considered to be specific others. Okay, now I'm going to focus now in this slide on right-wing populists and sexual minorities. So right-wing populists in some geographical contexts, as I explained before, consider sexual minorities as specific others. Right-wing populists in Central and Eastern European countries tend to consider calls for the extension of more rights and entitlements to sexual minorities, which claims traditionally come from international organizations or European supranational courts, as an imposition of Western values which clash with national values and national identity, which are perceived as being attached to tradition and religion, and which consider the traditional family as the foundation of society. So, to explain this, right-wing populists consider, in Central and Eastern Europe, consider that our society values the traditional family, they say. So sexual minorities are not part of our culture. We recognize and we value the family, but only when it takes the form of the traditional family. So when right-wing populists in Central and Eastern European countries are faced with claims coming from above, meaning from the supranational institutions, that they should extend further rights to the members of sexual minorities, then right-wing populists argue that there is now a battle between, on the one hand, the pure Central and Eastern European people that value the traditional family, and on the other hand, corrupt Western liberal elites that accept sexual minorities and, most importantly, want to impose their own views on the people, on the pure people of Central and Eastern Europe. Now, so the main argument of the paper is that judgments of European supranational courts or legislation originating at supranational, meaning EU level, are often viewed by right-wing populist movements as colonization attempts by a morally corrupt West, and can lead to backlash in contexts where such movements are influential. Now, what do we mean by backlash? Backlash simply means a reaction, and a negative reaction. And backlash can take different forms. So it can consist of non-implementation of supranational court judgments. And actually, we're going to see that a recent decision that was delivered by the, recent, the time goes quickly, a decision that was delivered, a judgment that was delivered by the ECJ 4 years ago, and which concerned the rights of sexual minorities, the cross-border recognition of same-sex marriages, has actually still not been implemented by the state, the EU member state that referred the case to the ECJ. Also, another form of backlash is exit threats. So actually, a good example of this is the approach of Russia towards the rulings of the European Court of Human Rights, and more broadly towards obligations imposed by the Council of Ministers of the Council of Europe. Many times Russia threatened that it would leave the Council of Europe, and actually you're probably aware that earlier this month Russia has actually been expelled from the Council of Europe. Or another example of backlash can be when a country or specific countries, in reaction to a specific policy, let's say, with which they don't agree, or with a specific legislative proposal that they do not agree, they veto a legislative proposal which aims to advance equality and in particular to protect the rights of sexual minorities. This is in particular possible, obviously, when the legal basis that is used for the proposed legislation requires that the proposal is accepted unanimously by all EU member states, in which case, obviously, this allows allows single member states to veto the proposal. So in the light of the rise of right-wing populism in Central and Eastern Europe, the European supranational institutions can face increasing challenges to their authority, which come in the form not only of backlashes which emerge as a result of individual rulings they deliver, or decisions that they make, policy decisions that they make, but also and more fundamentally as broader challenges to their overall authority. So sometimes we don't just speak about the possibility of a European state not liking a ruling of the European Court of Human Rights or not liking a ruling of the ECJ, but it could
I'm sorry, I think Professor Tryfonidou, I think you're muted.
Yes, you muted yourself.
Ah.
Okay, how did I manage to do that? Anyway, okay, thank you. Have I been muted for a long time, or I'm trying
just
to...
10 or 15 seconds.
Okay, I thought minutes, and okay, great. Right, so in the light of the rise of right-wing populism in Central and Eastern Europe, the European supranational institutions can face increasing challenges to their authority, which come in the form not only of backlashes which emerge as a result of individual rulings they deliver or decisions that they make, but also and more fundamentally as broader challenges to their overall authority. So they're no longer certain European states do not just question the ability, let's say, of the European courts to deliver a specific ruling, but then they go further and they actually start questioning whether their particular state should continue to be a member of, let's say, the Council of Europe or the EU. Okay, so this can actually attack even, let's say, the foundations of the supranational organizations like the EU or the Council of Europe. And actually, we have seen what happened in the UK with UK Independence Party, UKIP, which is actually an example of a right-wing populist party, very Eurosceptic one, that had it as its main life goal to ensure that the UK would leave the EU, and they found the right circumstances in the previous decade, and they actually led to, they highly contributed to Brexit. Okay, now so my argument is that the approach of the European institutions, and by this I mean European Court of Human Rights of the Council of Europe, the ECJ of the EU, as well as other EU institutions, shows signs of reticence, meaning of restraint, especially when it comes to the imposition of positive obligations on states with regard to the grant of family rights to the members of sexual minorities. Now, a small parenthesis here. When we speak about positive obligations, these are obligations which are imposed on states to actually do something. For example, a positive obligation is if states are required to introduce same-sex marriage in their territory. On the other hand, we have negative obligations, which are simply requirements imposed on states to refrain from doing something. For example, a negative obligation is a requirement which is imposed on states to stop torturing people, etc., etc. So obviously, positive obligations are somewhat more controversial and more interventionist in the sense that they require states to actually do something. Okay, now, after all this quite long introduction, I'm going to cut to the chase, and I'm going to start by seeing the approach of the European Court of Human Rights in cases involving claims brought by LGBT persons where they were claiming specific family rights. And in the end, I'm going to explain what may have been the reasons behind the court's approach in these cases. So, before the European Court of Human Rights, LGBT persons have claimed the right to marry a person of the same sex, the right to have their marriage contracted in another country with a person of the same sex recognized in an ECHR signatory states, the right to have their relationship with a person of the same sex legally recognized, and the right of same-sex couples to act as the joint parents of a child and to be legally recognized as such. Now, as regards same-sex marriage under the European Court of Human Rights case law, the Court of Human Rights the European Court of Human Rights has made clear in a relatively long list of cases that the European Convention on Human Rights does not impose a positive obligation on states to open marriage to same-sex couples in their territory. This was firstly explicitly held in the Schalken-Kopf case against Austria in 2010, but has since been repeated a number of times, and actually it is still the position of the European Court of Human Rights to this day. The reasoning of the court has more or less stayed the same with regard to this matter. So initially the court starts its reasoning, as it did in the first case where this issue was discussed, by saying that only a small minority of Council of Europe member states have open marriage to same-sex couples. Back in 2010, when the Schalken-Kopf case was decided, it was only 6 out of 47 Council of Europe member states that had opened marriage to same-sex couples. Now the number is bigger, obviously, but still it's a minority of Council of Europe member states that have done so. Then the court always admits that marriage is subject to the national laws of the contracting states, in this way accepting that family law and issues having to do with marriage fall within the purview of national competence. The court then has said that in the 1950s, when the European Convention on Human Rights came into force, marriage was clearly understood in the traditional sense of being a union between partners of different sex. And at the same time, it also rejected the argument that the notion of marriage within the ECHR context should now be read in the light of present-day conditions. Noting that although the institution of marriage has undergone major social changes since the adoption of the convention, there is no European consensus regarding same-sex marriage. This is a very important point which has been emphasized by the court, the lack of European consensus on the topic. So the court concludes that the question whether or not to allow same-sex marriage is left to regulation by the national law of the contracting states. And this is because marriage has deep-rooted social and cultural connotations, which may differ largely from one society to another. And therefore, the court must not rush to substitute its own judgment in place of that of the national authorities, who are best placed to assess and respond to the needs of society. Okay, so in Schalken-Kopf, and this has been repeated in subsequent case law as well, the court said there is no consensus, there is no agreement among European states as to whether there should be same-sex marriage. This is a sensitive moral issue. Marriage is a very special, unique institution which has deep-rooted social and cultural connotations. So the court says it's not my job to make decisions regarding this, but rather it should be left to the individual states to decide whether they will introduce same-sex marriage in their territory. In the Orlando and others against Italy case, the court actually followed the same line of reasoning in a case which didn't involve the introduction of same-sex marriage in the national context as such, but rather the cross-border recognition of same-sex marriages. So in this case, we had Italian couples who entered into a same-sex marriage abroad, where this was permitted, for instance, in Canada. And then when they came back to Italy, they wanted their marriage to be recognized. When they applied to the Italian authorities for this to happen, this was refused. So they were considered as not being in any, not having any, let's say, familial tie between them. The European Court of Human Rights held that the state where the claim for recognition was made should recognize the same-sex relations, should legally recognize the same-sex relationship of the couples that were applying to it, albeit not necessarily as a marriage. So again, this special status of marriage and the fact that the European Court of Human Rights didn't want to touch it at all, but rather it wanted to leave it to states to regulate it and to decide who can enter into marriage, is confirmed again in the Orlando case. So the above case law demonstrates that the European Court of Human Rights accepts that traditional marriage maintains a special privileged status. Moreover, given its privileged status, marriage, according to the European Court of Human Rights, can give to those that have contracted it special rights and entitlements. So as we're going to see later, if, for example, a state which has not opened marriage to same-sex couples decides, for example, to allow only married couples to adopt a child, this means automatically that same-sex couples, they cannot adopt a child, but that is considered by the European Court of Human Rights as not amounting to discrimination against same-sex couples, because simply it is considered that married couples on the one hand and unmarried couples on the other are not similarly situated, so a difference in treatment between them does not amount to discrimination. I analyzed this point a bit more in the working paper, but obviously I don't want to spend much more time on this here. Now, so we've seen the position with regard to same-sex marriage. The court's approach, the European Court of Human Rights approach, however, with regard to the legal recognition of same-sex relationships is different, and actually it's more positive. So in 2013, in the Vaganatos against Greece case, the European Court of Human Rights held that Article 8 ECHR, the right to respect for private and family life, read in conjunction with Article 14, which prohibits discrimination on a number of grounds, requires signatory states that have introduced registered partnerships for opposite-sex couples to extend these to same-sex couples. So from the moment that a European state, a member state of the Council of Europe, decides to introduce a status which offers recognition to relationships which is not marriage, this status has to be open not just to opposite-sex couples, but also to same-sex couples. The court actually took one step further, a very important step actually, in the Laulhé and others against Italy case, where it held that Article 8 ECHR imposes a positive obligation on signatory states to put in place a legal framework for the legal recognition of same-sex relationships. So, although marriage maintains a special status as it is deeply rooted in tradition and culture, and so on this basis, states should still be able to choose whether they will exclude same-sex couples from it. Nonetheless, the court has recognized that same-sex couples must have the right to have their relationships legally recognized in some way. And I underline the words in some way. However, after the Laulhé judgment was delivered, and because if you read the judgment, the quite long judgment, you will see that the court actually placed a lot of emphasis on the actual legal and social context of the specific state against which the application was brought, Italy. The question arose as to whether the result of the case was specifically applicable only to that member state or states which had a similar legal and social context. However, last summer in the Fedotova and others against Russia case, where the same issue arose, albeit in a different geographical context, in Russia, where obviously the approach towards sexual minorities is much different, and where there is no discussion at all for introduction of legal recognition of same-sex relationships, the European Court of Human Rights held that Article 8 did impose a positive obligation on Russia to introduce some kind of a legal framework for the legal recognition of same-sex relationships. Well, I'm not going to, or should I? Well, I don't want to spend too much time on this. Obviously, Russia wasn't very happy with the judgment of the court in the Fedotova case, because that meant that it would have to introduce a legal framework to legally recognize same-sex relationships. So it actually applied for the case to be referred to the Grand Chamber of the European Court of Human Rights, and actually this happened in November. So the case was actually referred to the Grand Chamber of the European Court of Human Rights. So the decision of the Grand Chamber is currently pending. Things, of course, are complicated by the fact that Russia is now, since is no longer has been expelled from the Council of Europe, and obviously the jurisdiction of the European Court of Human Rights with regard to Russia will terminate in September. So it's questionable whether we're going to get a clarification through a Grand Chamber ruling in the Fedotova case. In any event, the matter is going to be clarified soon, because there is a large number of pending cases against Poland, which has relatively quite a similar social legal context with Russia as regards same-sex relationships. So we may get, we expect to receive, let's say, an answer in those cases, if not in Fedotova. Okay, now, so we have spoken so far about the approach of the European Court of Human Rights to same-sex marriage. We said it doesn't want to touch it. Then we have seen actually that it adopts a more interventionist approach as regards legal recognition of same-sex relationships in other ways, by imposing a positive obligation on states to actually introduce legislation which allows same-sex couples to formalize their relationship. What happens with joint parenting by same-sex couples? We have a same-sex couple, they want to become parents. What does the ECHR require states to do? Are states required to enable same-sex couples to become parents and to be legally recognized as such? The first point I would like to emphasize is that the European Court of Human Rights, even in cases having nothing to do with sexual minorities, has established that there is no right to found a family deriving from the European Convention on Human Rights. So the convention does not impose a positive obligation on states to enable couples, whether opposite sex or same sex, to become parents and to be legally recognized as such. However, once procreation rights are recognized or provision is made for enabling certain categories of persons to become parents and to be legally recognized as such, these rights must be granted without discrimination on any of the prohibited grounds laid down in Article 14 ECHR, which has been read as including sexual orientation within the grounds, within the prohibited grounds. So, for instance, in EB against France, it was held that when single persons are allowed to adopt children. It shouldn't matter what is the sexual orientation of the single person that wants to adopt, and actually LGBT persons shouldn't be excluded from adoption on the basis of their sexual orientation. So in the Ex Nullis against Austria case, there the European Court of Human Rights held that unmarried partners should be treated equally when it comes to the issue of second parent adoption. So, for example, if unmarried opposite sex couples are allowed if the unmarried opposite sex partner of a person is allowed to adopt that person's child, that should be allowed also in situations where we have a same-sex, the unmarried same-sex partner of a parent. In Gaz and Dubois, however, there we have the issue of marriage and the special status reserved for marriage, for married couples. Because in that case, France reserved step-parent adoption only for married couples, meaning, let's say, if we had a person who had a child from a previous marriage or from a previous relationship, and then they married someone else, France provided in its legislation that the new spouse of the parent was allowed to adopt the child. However, if the partner of the new partner of the parent was not married to the parent, then France didn't allow step-parent adoption. Because France at the time had an open marriage to same-sex couples, this meant automatically that step-parent adoption wasn't available to same-sex couples. When the issue was referred to the European Court of Human Rights, the European Court of Human Rights said, tough luck, this doesn't amount to discrimination on the grounds of sexual orientation because married and unmarried couples are not similarly situated. I don't have the time now to get into criticism of this approach. There is clearly discrimination in this case. And actually in another case, in a different context, the European Court of Human Rights did recognize it in a case which was less controversial because it didn't involve same-sex parenting, but rather the immigration rights of a same-sex couple. But that is the approach. So generally, when it comes to parenting by same-sex couples, to date, the court only had to deal with cases which involved alleged discrimination against same-sex couples. However, at the moment, there are lots of pending cases involving the cross-border recognition of the familial ties between a child and both of her same-sex parents. Also, we recently had 2 surrogacy cases, but they don't have any special interest for our purposes because they involve surrogacy, which is a very special issue, and where in those cases the court simply adopted exactly the same restrictive approach as it adopts in situations which involve surrogacy and opposite sex couples. So it doesn't have any specific interest for us. Okay. Now, so to summarize the approach of the European Court of Human Rights to the family rights of sexual minorities, the first point to make is that the court accepts and recognizes that there is no consensus in Europe as to what constitutes a family. Also, there is no consensus in Europe as regards the family rights of sexual minorities. Some European states have been pioneers with regard to this matter. For example, Netherlands was the first country in the world to introduce same-sex marriage in 2001, if I remember well. And Denmark is the first country in the world to introduce same-sex registered partnerships in 1989. At the same time, we also have some of the more backward countries in the Western world when it comes to sexual minority rights. The Council of Europe, in particular the European Court of Human Rights, has had to take into account that within its membership, it has, let's say, a rather polarized let's say, it has a polarization with regards to attitudes towards this matter. So with regards to matters for which there is no European consensus, the European Court of Human Rights has developed interpretative strategies that allow it to proceed with restraint. And as you probably know, the main such strategy is the so-called margin of appreciation. So the court holds in its judgments, not just judgments involving sexual minority rights, but in judgments where, first, there is no European consensus, and secondly, they concern sensitive ethical and moral issues. In those cases, the court leaves a margin of appreciation to states, meaning it allows them leeway in recognition of the cultural and political differences between them. So it recognizes that with regard to certain matters which are more controversial and sensitive from an ethical and moral point of view, states are a better place to make decisions, and so it doesn't want to impose its own views on them. Okay, now, so what we have seen from the previous cases is that the European Court of Human Rights is granting a great deal of difference to states in deciding which family rights to extend to sexual minorities. What we have seen is that effectively what the European Court of Human Rights has done is to provide a floor of protection, which requires European states to establish a legal framework for the legal recognition of same-sex relationships, and to refrain from discriminating against LGBT persons and same-sex couples. But it still considers that the time is not yet ripe for imposing an obligation on states to allow same-sex marriage. This, as I explained in my working paper, will be the final battle. Allowing same-sex couples to marry is considered to be the utmost legitimization of same-sex relationships. So imposing this from above on European states will certainly meet the objection of many European states, especially those which, even though they allow same-sex couples to formalize their relationship in some way, they still maintain a constitutional ban on same-sex marriage, defining it as a relationship between a man and a woman. This is, for example, the case in Croatia and Hungary. Now, objections to a positive obligation being imposed on states with regard to the introduction of same-sex marriage are likely to arise in particular in Central and Eastern European states where right-wing populist groups are influential. Remember, we spoke about right-wing populist groups, and we said that unlike left-wing populists, right-wing populists are concerned more with ideological issues. So they take the nation and they consider themselves to be the protectors of the nation, the protectors of the pure people from the bad influence of the corrupt Western elites, etc., etc. So the objection to same-sex marriage clearly has an ideological character. If states decide not to comply with an obligation, a potential obligation, which may be imposed to introduce same-sex marriage, they will not do it because this would be too costly for them. It doesn't cost anything, but rather they will do it on ideological grounds. So this shows that it is an issue that will almost certainly raise the objection of right-wing populists in Central and Eastern European states. Most importantly, however, and I think that this is the most essential point here, is that the court is aware that in Central and Eastern European states, and we know this from surveys that are still being conducted, there is still passionate opposition to same-sex marriage in some parts of the society, and in some countries it's still even the majority of people that are against same-sex marriage. So what this means is that if the European Court of Human Rights rushes to impose obligations on states with regard to same-sex marriage, then this is actually going to enhance the position of far-right populists. So, in other words, if the population of a state where the majority is against same-sex marriage is told that, well, we are obliged by the European Court of Human Rights to introduce same-sex marriage, then they will automatically feel that this is something that is imposed from outside. It will obviously create a reaction, and this will actually be the perfect opportunity for right-wing populists to actually further enhance their position, because now they will be considered to be the heroes and the defenders of the nation from external interference. So I think that that is one of the main reasons that the European Court of Human Rights is taking such a reticent approach, especially with regard to the issue of same-sex marriage. Now, with regards to the EU and the European Court of Justice, things are a bit simpler here in terms of how I will present them, in the sense that, as you probably know, the European Union was created back in the 50s in the form of 3 economic communities. Later in 1993, we had the expansion of it and its aims, of the communities and their aims, into the European Union, which was broader. It wasn't just about the economy now, but it included the communities as one of its 3 pillars. Now, when it comes to sexual minority rights, we have to remember again that the EU does not have competence in the family law field, apart from when family law issues have cross-border implications. Now, so this means that in the EU context, LGBT rights have only been tangentially touched upon by the ECJ, and the ECJ has never been directly called to rule on issues like the European Court of Human Rights has had to deal with, simply because it doesn't have jurisdiction, and simply because the EU cannot in any way deal with the issues having to do with human rights or family law issues, apart from in situations where EU law as such is involved. So far, questions regarding the legal recognition of same-sex relationships and the consequences attached to them have arisen only initially in the employment context, and required the court to provide an interpretation of the EU's relevant anti-discrimination legislation. However, here I want to emphasize that in that case law, the European Court of Justice wasn't asked to rule on whether, for example, a member state, an EU member state, should introduce, as a matter of EU law, a legal framework for the legal recognition of same-sex relationships, but rather the question was whether, when such a legal framework was introduced in a member state, what should be the rights that would ensue in order to ensure that there was no discrimination on the ground of sexual orientation in the employment field, which is something that is prohibited by EU law. Okay, now, in the last 4 years, the European Court of Justice has been confronted with 2 free movement cases, which raised the issue of the cross-border recognition, first, of same-sex marriages, and secondly, of the familial ties between a child and both of her same-sex parents. So, in the Coman case, the first case of the 2, Romania, okay, no, let me start from the beginning. So, we had Mr. Coman, who was a Romanian national, and he was in a relationship with Mr. Hamilton, who was a US national. They got married in Belgium, an EU member state, and Mr. Coman, relying on EU free movement law, wanted to return to Romania, and he wanted to claim family reunification rights, simply the right for his spouse, his same-sex spouse, to accompany him in Romania on his return after having exercised free movement rights. So the question was whether the directive that is applicable to free movement cases in situations where a union citizen like Mr. Coman moves between member states was whether the term spouse within the context of that directive should be interpreted to include both opposite sex and same-sex spouses. And the ECJ held that, yes, member states are required to recognize same-sex marriages contracted in other member states for the purpose of the grant of family reunification rights in situations where there is an exercise of free movement rights. To put it simply, the Coman case established that when a union citizen, meaning a member state national, is married to another person of the same sex and the couple got married in an EU member state, then wherever they move within the EU, they should be recognized as spouses for the purpose of determining whether the spouses, the other spouse, the non-EU citizen spouse, is entitled to join and to be given a residence right in the member state to which the union citizen moves in exercise of free movement rights. In the judgment, in the case, a number of governments, in particular the Latvian government, stated that the court should rule that the term spouse doesn't include same-sex spouses, because because although this may lead to obstacles to the free movement of union citizens, contrary to the relevant provisions of EU law, such a restriction to free movement is justified on grounds of public policy and national identity. However, the ECJ said such an argument is not accepted because the obligation for a member state to recognize a marriage between persons of the same sex concluded in another member state, in accordance with the law of that state, on the facts in Belgium. And I emphasize here, as the court did, for the sole purpose of granting a derived right of residence to a third country national, does not undermine the institution of marriage in the first member state, which is defined by national law and falls within the competence of the member states. Such recognition does not require that member state to provide in its national law for the institution of marriage between persons of the same sex. Okay. In other words, what the court emphasized in its Coman judgment is that there is an obligation under EU law to provide cross-border recognition of same-sex marriages contracted in an EU member state, but only for free movement purposes and only in particular for the grant of family reunification rights under EU law. So what has been remained unanswered in Coman has been whether, what happens when same-sex spouses move between member states and they wish to be recognized as married, not for family reunification purposes, but for other purposes. So let's say Mr. Coman and Mr. Hamilton, they're both admitted into Romania and they're given a right. Once they're there, can they claim from the government, let's say, taxation treatment which is reserved for married couples will be recognized as married for that purpose? For that purpose, what happens with pensions and all this? Obviously, because that is an even more controversial question, and because the question wasn't raised in the case, it was just about the residence right, the family reunification rights, the ECJ chose obviously to avoid to answer it. I guess the ECJ would prefer not to have to answer it soon, because then if it rules that same-sex marriages should be recognized in a cross-border context for every legal purpose, then it might be accused of introducing same-sex marriage in member states through the back door. Okay, then we have the VMA case, which was, the ruling was delivered last December. In this case, we had two women who were married. One is a British national, the other is a Bulgarian national. They had a child in Spain. The child has a Spanish birth certificate which notes the two women as the mothers of the child. The Bulgarian mother wanted to register the child in Bulgaria and for the child to have a Bulgarian birth certificate and a Bulgarian passport. However, the Bulgarian authorities refused to issue a birth certificate because essentially the reason was that it couldn't recognize the two mothers, two persons of the same sex as the joint legal parents of a child. The Advocate General in the case noted that what is at issue in this case is a very sensitive matter, given the exclusive competence of the member states in the area of nationality and family law, and the considerable differences that exist to date within the European Union in respect of the legal status of and the rights conferred on same-sex couples. So again, very controversial question. It touches on family law, it touches on nationality issues as well, because there was a particular point which I don't mention not to complicate things, but it involved nationality issues as well. What the court held, again, I'm oversimplifying here, but that's what is important. In this case, the ECJ held that the principle of mutual recognition applies to birth certificates issued by EU member states, including when they identify two persons of the same sex as the parents of a child in situations which involve the exercise of free movement rights. So what this means is that if a same-sex couple has a child who is recognized as the child of the couple, or as the joint child of the couple in one member state, then the VMA case established that when the couple, when the family moves to another member state, then the familial ties established in member state A, here Spain, should be recognized in every other member state, irrespective of whether the host member state recognizes and gives the right to same-sex couples to be the joint legal parents of a child in its territory in purely internal situations. Okay, this is important practically because it means that rainbow families, meaning families where the parents are of the same sex, can now move together. All members of the family can be safe and know that they will move together, and the host member state will be required to admit them within its territory. Okay. Have, again, like in Coleman, in this case, the court didn't have, and obviously it was very happy to be able to avoid to have to engage with the very difficult question of whether the cross-border recognition of the parent-child relationship between the child and both of her parents applies not only when it comes to the question of family reunification rights, like was the issue on the facts of the case, but also when the family is within the host member state and when they want to be recognized as a family for other legal purposes. So, for example, once a rainbow family has been admitted into a state, is that state required by EU law to recognize the both mothers, let's say, as the mothers of the child for when it comes to things like giving consent to medical treatment for the child, registering the child at school, for both parents to be able to apply, for the child to be able to inherit from both parents, etc., etc. So again, the court was able to avoid having to deal with this more controversial issue. Delivering a ruling which explicitly requires this, meaning cognition of the parent-child relationship with regard to both parents for all legal purposes, would almost certainly raise the objection of EU member states which do not make provision for joint parenting by same-sex couples, and which obviously vehemently object to the idea of recognizing two persons of the same sex as the joint parents of a child. If same-sex marriage is considered a controversial issue, joint parenting by same-sex couples is 10 times more controversial. So you can understand that the court is in even more of a difficult position here. Okay, so a more, let's say, interventionist approach in the VMA by the ECJ would almost certainly lead to a backlash in some EU member states. And here I would like to note that when it comes to, as regards the Coleman case that we saw before with the cross-border legal recognition of same-sex marriages, 4 years have passed since the ruling. Romania hasn't complied with it. So it hasn't given a right of residence to the husband of Mr. Coleman, despite the fact that the ECJ said that it should do so and that it is required to do so by EU law. As a result of this, actually, Mr. Coleman and Mr. Hamilton brought a case now before the European Court of Human Rights, but I'm not going to discuss that further. So, given that Romania didn't comply with Coleman and possibly a number of other member states who may be confronted with this issue and do not have same-sex marriage in their territory, they may also refuse to do that. It's quite clear that if there was an imposition of an obligation to for cross-border recognition of same-sex parenting, would again meet with a similar denial to comply. Okay, so accordingly, the two rulings in which the ECJ was called to directly consider the claims of the members of sexual minorities for the cross-border recognition of their family rights demonstrate that the ECJ makes strategic calculations in its decision-making, avoiding decisions that could create a political backlash. This appears to be an apt response in the current political climate, whereby the various crises that have battered Europe in the last decade or so, such as the migration crisis, the refugee crisis, the financial crisis, all of these crises have provided fertile ground to the right-wing populists in Europe, especially in Central and Eastern Europe, to use the EU as a scapegoat and to fuel an increasing anti-EU sentiment. So what we can see here is that the court is doubly cautious, I would say, because on the one hand, it doesn't want its rulings not to be complied with, as has happened with Coleman. And at the same time, already the EU has been accused and has been turned into a scapegoat for a number of crises that have happened in Europe, have occurred in Europe, like the refugee crisis and the financial crisis. So already there is a general anti-EU climate, especially in some countries. So the last thing that the EU would need now would be also that to be accused that it is trying to impose its views with regard to sensitive ethical and moral issues, where there is clearly much difference in opinion among European states. Now, the final thing, I know it's been a very long lecture. Despite what we have seen and the reticence of the ECJ, there is a rather positive, say, development. The European Commission, actually initiated enforcement actions under Article 258 last summer against Poland and Hungary. And the reason for this first was, as regards Poland, the fact that Polish authorities actually supported the decision of some Polish municipalities to introduce LGBT ideology-free zones meaning that in those municipalities, for example, there can't be any gay pride parades or any expression of support for LGBT rights. So this, someone could say, is a clear violation of the right to freedom of expression, the right to the freedom of association of sexual minorities, etc., etc. And also as regards Hungary, Hungary introduced last year, as you may be aware, a so-called, I would call it, a gay propaganda law, similar to the Russian one introduced in 2013, where basically any content, whether books or anything else, which promotes or portrays homosexuality as good, or which in some way shows that it approves of it, or even simply gives information with regard to homosexuality and same-sex relationships, then this is prohibited. Actually, there was a similar law in the UK back in the 80s, which was considered very bad subsequently, and the UK is still quite embarrassed about it. So the Commission, despite all the issues that we actually mentioned previously, decided to take action against these two member states with regard to actions they have taken which clearly violate the rights of sexual minorities. We don't know what will happen with these actions because they are currently pending, but it will be interesting, obviously, to see what will happen. However, the fact that we have these actions, and taking into account also what the court ruled in the cases that we mentioned, shows actually that the danger of a backlash in EU member states that are ruled by right-wing populist governments can have a different impact on the approach of EU institutions depending on the nature of the right that is at issue. So, in particular, remember when I explained what is a positive obligation at the beginning of this lecture? Well, EU institutions, including obviously the EU judiciary, appear more reticent, more reluctant to impose positive obligations on EU member states, such as the requirement to grant specific family rights to the members of sexual minorities. Whereas when it comes to negative obligations, meaning the obligation not to violate the rights of sexual minorities, the EU institutions, in particular the Commission, appear more willing to disregard a potential backlash. So especially where violations directly attack the dignity of LGBT persons, such as has been the case in, for example, in relation to the Polish LGBTI-free zones policy. So these are my thoughts on the matter. I'm happy to receive any questions or to discuss something further. Thank you very much.
Thank you so much, Alina. This was, as usual, very thorough and very well explained, very clearly. I have been following your lectures for the past 15 years. So actually, you know, I just got a memory on Facebook that your previous guest lecture was actually exactly 6 years ago. It was on the 20th
oh, wow.
of March, 6 years ago. So that's interesting. So I am amazed at you know, the comparative work that you've been doing. So this is extremely interesting at the supranational level. Both you and I are traditionally, you know, EU law experts, and we have ventured, you know, through different directions into European law more broadly. So this is extremely interesting, and of course it raises many different issues. I have a key question for you, but I don't want to keep the floor. So I was wondering whether anyone has questions for Professor Tryfonidou. We have a few minutes, about 10 minutes to discuss. And Andreas, please feel free to come in as well.
I also have a question, but let's see if anyone else wants to ask something, and then we can go ahead, I guess.
Yes. there is a nice comment from Maria Paraskeva in the chat saying that VMA case is important in symbolic terms because it demonstrates that families are families. Yes, of course, and it is a nice terminology actually. Anyone would like to type in the chat or take the floor? You're very welcome to, briefly take the floor. And if not, yes, there's a, no, that's Nicolas. It's not a question. It's to encourage participants to give us feedback on the guest lecture. So thank you very much, everyone, for giving us feedback, please. And thank you, Nicolas, for this. Andreas, what is your question related to? Is it more on the key concepts? Because for me, it's on the consequences, so it's better to keep it for the later.
No, so my question is a bit more practical, right? Because I've seen your explanation of the different cases from the Court of Human Rights, and I was wondering, so in practical terms, within the European Union, there are some countries that, as you mentioned, they are subject to infringement proceedings for certain actions that violate certain rights of sexual minorities. So my question is, you showed that you are reluctant in accepting a specific legitimacy to the court to decide those cases for countries, right? And I agree with you on that. I don't think that is the way forward. So my question is, do you think there is something in the quiver, let's say, of the European Union that could help to promote and protect those rights in countries given limitations because of family law being outside the competences of the European Union?
Well, what I'm thinking as the only option is not something very positive, and actually, in practical terms, I can see the let's say the usefulness of it. And this is, I think, that with regard to matters like this, where there is so much polarization, in the end, we will end up in a multi-speed Europe with regard to this issue as well. So I think it's more of an issue of agreeing to disagree. And especially in the current climate where we have all these crises going on and we had Brexit and all this, I think the EU should be, I don't want to sound like a Cassandra and thinking that, all bad things are going to happen, but I think it's a particularly sensitive time for the EU. So the last thing it would want is to be accused that it's trying to, let's say, corrupt some member states, because that's what populists, right-wing populists, are arguing, and impose its views with regard to issues which are indeed very sensitive. I mean, the rights of sexual minorities, in particular their family rights, have been very controversial, not just in Europe, but even in the US and in many other contexts. And we are speaking now also about the Occidental world. We don't go to, more conservative, let's say, socially conservative countries. So I think at the moment, at least, especially since there is no majority of member states supporting the extension of these rights to same-sex couples, I don't think the EU can do anything. With the European Court of Human Rights, I think because it's a human rights court, then there is more of a, let's say, it's more appropriate for it to act. But again, I believe that at the current circumstances, in the current climate, it's better for it to focus, as I would say, more on when it comes to negative obligations. So rather than requiring member states to give more rights and to create more rights for sexual minorities, it would rather be better in the first place to ensure that the rights of sexual minorities are not breached by states. This should be the very first and immediate step. And then once we solve this, then there should ideally be further movement to require member states to impose positive obligations on states.
Thank you, Alina. Andreas, do you have a follow-up question, or should I go for the question in the chat?
No. I do have a follow-up question, but let's hear from others as well. Okay,
thank you. There is a question in the chat that is actually relevant to what you were discussing now. And it reads as follows: would or could the influence of the two European courts on each other help with developing the protection of sexual minorities? I think you have partly addressed it, but I mean, obviously, this wouldn't be the first time that they influence each other.
Yes. Yeah, actually, I think that, there is actually a very nice chapter on the, and actually it's about, in particular, sexual orientation discrimination, the rights of sexual minorities. There is a very nice chapter by Robert Wintemute. I think it was published back in 2015 in an edited collection, where exactly the interaction of the two courts with regard to this matter is explored. And it's actually quite impressive to see that, despite the fact that we would think that it's the European Court of Human Rights as a human rights court that would go forward and would, protect the rights and would make the first step for the protection of the rights of sexual minorities, in the end, that's not always what happens, but rather the European Court of Justice can actually be applauded for, to a certain extent, upholding the rights of sexual minorities. So how could the influence of the two European courts help with developing the protection of sexual minorities? Yes, for instance, the fact that already there is a positive obligation imposed in Oliari and now in Fedotova to introduce some kind of legal recognition of same-sex relationships, which was introduced by the European Court of Human Rights, then I think this helps, let's say, the ECJ to build on that, and then to, in its anti-discrimination case law, where it needs to, to adjudicate on issues where there are registered partnerships and to extend rights and all this, then it has already the basis coming from the European Court of Human Rights. I think that I'm not explaining myself clearly, but...
Well, I think it's quite clear. Now, Andres and I, I'm sure, are very eager to ask questions, but there is another one in the chat which I think was about to come up, so it has come up. Would it be possible to say how or where do you think Cyprus is, politically in parentheses, I'm not sure whether we can do the politically, but we can try, oriented in this context in comparison to other European countries? I mean, we can definitely do the legally, the politically.
Well, I mean, obviously we have same-sex registered partnerships. We don't have same-sex marriage. It's not even discussed. The church has quite a lot of power. So I think these are the main issues in this context. Well, I would see Cyprus as somewhere more or less in the middle when it comes to its position in Europe and its approach towards sexual minority rights. So yes, it's never going to be one of the pioneers, far from it, when it comes to sexual minority rights. But at the same time, it doesn't have very strong ideological grounds of objection towards sexual minority rights. Especially, I believe, if we didn't have the influence of the church, then I think we might be a bit more, we would probably be in slightly better position with regards to the legal recognition of same-sex relationships. I actually have in mind Malta, which is a small state like Cyprus. It's a Catholic state, so someone might have expected it to be more or less in the same situation as we are. and yet it always comes at the top of the ILCA Europe map in terms of the legislation and the rights that it gives to sexual minorities. So I wouldn't be very pessimistic. The problem, however, I think also is that, well, we record this, is that there is not much awareness at government level, and and I don't just mean at the political level, but also at administrative level, as to the requirements imposed by EU law, as to the judgments, as to the resolutions issued by European institutions and all this. So Cyprus needs education, first of all, and public discussion, which is completely absent with regards to these matters, apart from some nasty Facebook comments that I see. So, yeah, I don't know. I don't think that there will be a discussion about same-sex marriage in the next 5 years. With regard to and what I feel is that because there is no clear ideological objection to these matters, the Cypriot authorities will probably, if they can help, let's say, and not refuse the rights to certain rights to LGBT persons, they will do that. But obviously, this doesn't ensure that there is legal certainty. So probably what I feel is that they deal on a case-by-case basis with various issues that involve the rights of sexual minority, but there is no, but this means that there is no legal certainty, which is obviously problematic.
And itself perhaps potentially a breach of fundamental rights in itself.
Exactly. Yeah.
Just one short comment, but I won't ask a question. So this is very interesting because this is where I wanted to take you as well. I wanted to take you to, what happened next. This is extremely important research. This is research that resonates with, societal issues that are timely, that are important. You mentioned the need for education. You mentioned the need for public discourse. And I would encourage you to perhaps also look into the possibilities of what we call strategic litigation, which is another way to try to change things. So not necessarily by going directly, to any sort of supranational courts. There are many other ways that strategic litigation can be useful and to which an academic can be useful. Because the academic work is scientifically evidenced, it's objective, and therefore it can be helpful to other groups, non-academic groups, such as lawyers, like we have today, for example, or civil society organizations, or interest groups, to be able to raise certain matters nationally, but also supranationally. So I would like to encourage, this kind of debate. We can, of course, pick that up outside of this guest lecture. We were trying to do something similar for human trafficking. So can share with you sort of like best practice and how we are approaching it and how we engage with the legal professionals nationally and internationally to try to do that, for example.
Definitely. And actually in the European context, so organizations like ILCA Europe and all this, they are now focusing so much on strategic litigation because they think it's the way forward. And that's why I mentioned there are lots of cases pending now before the European courts, both actually European courts, exactly because there is this emphasis now on strategic litigation.
But even, reporting or monitoring and reporting are tools of strategic litigation in the sense that you could also try to influence non-lawmakers, so more like policy makers and international organizations that actually are responsible for monitoring the implementation of fundamental rights in specific jurisdictions. So it's not only the courts, it's also other decision-making bodies and branches of government. So this is what is very interesting about
the ombudsman as well.
And for example, exactly. Andreas, do you want to give a word of conclusion? Thank you for the very nice comments that we have in the chat. People are very happy. Thank you for joining us and listening and being patient. Indeed, it's very interesting and very, we're very happy that we're able to discuss this in depth. Andreas, if you want a last word.
So first of all, let me thank Professor Tryfonidou for her speech and for her answers. There's so much that I'd like to say, but since we've run out of time, I'd just like to say that I completely agree with your assessment in terms of where we are within the European Union and things that the European Union can do with respect to right-wing populism. And I think that is clearly one of the reasons why research in the area of human rights, the rule of law, and democracy with respect to right-wing populism is so immensely important and timely, because it really pinpoints the shortcomings of the European structure in that respect. So thank you very much for your lecture, and we look forward to seeing the working paper and for future collaboration.
Thank you so much for having me, for giving me the opportunity to do this, and actually for suggesting populism, because I never did any work on this, and it's such an interesting topic. So thank you again.
You're very welcome, Alina. Thank you, everyone. We will be back with more activities, including the final conference. And Alina, you're of course invited to be with us, and everybody's invited, but also the summer school where we go into depth into various aspects of populism. Thank you, everyone. Be safe. See you soon. Bye.
Thank you. Good night.